I want to welcome you to a wonderful afternoon of learning about the world and bringing it home. I'm very excited that International Programs is partnering with the law school to present an afternoon of talk about international human rights. I want to welcome you to one of my homes, which is the law school, and tell you that we're thrilled that we're doing this here and that you're all here. I want to thank everybody who participated in putting this program together. It's a lot of work of a lot of people throughout campus, as well as some of the staff at the law school, and we appreciate that. I want to thank you all for being here, and just say that we all here think this is the most amazing and significant topic, and we're looking forward to the afternoon and learning about all of this. So thank you, people from here and people from all over the world.
I would like to also begin by thanking International Programs for its enthusiasm and support for this week's activities, including this human rights panel here today. I'm grateful for Associate Provost Kia's vision of international understanding and his hard work and dedication to the University of Montana. We here in Montana are extremely lucky to have him not only as a distinguished scholar and a passionate professor, but also an administrator leading international education here on UM campus. I would also like to thank the law school. I graduated here now almost 25 years ago, and I took an international law class back then, and a lot has happened since then, and so I'm very excited to see the law school sponsor this organization, this panel. I'd like to thank Dean Russell, Jerry Burke, and many of the staff, including patients, who without their work, we wouldn't have the CLE here today. And I would like to thank all of you. Without the commitment of so many people in the community and on this university, we wouldn't have the world that we live in today. So, I am Andrea Olson, and I'm honored to be part of bringing international human rights home to Montana. Modern human rights begins with the Universal Declaration of Human Rights. First Lady Eleanor Roosevelt, who was chairman of the Human Rights Commission at the time of the adoption of the Universal Declaration of Human Rights, considered by some to be the mother of the document itself, was the first to demand that we bring international human rights home to the people. As I read her words, I would like to show you the provisions of this foundational human rights document, which you should also have a link. There's a page that will give you a link to the whole thing. I'm going to read her words and go through it. I think that this audience probably all has read the Universal Declaration of Human Rights as I look around the room, so I apologize if you feel like this is too elementary. But she said, and I quote, "Where, after all, do universal human rights begin? In small places, close to home, so close and so small that they cannot be seen on any maps of the world. Yet they are the world of the individual person, the neighborhood he lives in, the schools and colleges he attends, the factories, the farms, the office where he works. Such places are where every man, woman, and child seeks equal justice, equal opportunity, equal dignity, without discrimination. Unless these rights have meaning there, they have little meaning anywhere. Without concerned citizen action to uphold these rights close to home, we shall look in vain for progress in the larger world." Okay, and I practiced that, and so now you have quickly seen the Universal Declaration of Rights. Human rights, now embodied in a large set of United Nations treaties, conventions, and declarations, has always been a concern of humanity and continues today to require further discussion and development. Human rights may be generally defined as those rights which are inherent in and applicable to all human beings. Human rights combined with fundamental freedoms allow us to develop fully. Throughout history, humankind increasingly demanded life in which the inherent dignity and worth of each human being is worthy and deserves respect and constitution and protection. And as you can see, the Montana Constitution, in the Montana Constitution, we have a specific statute that says the dignity of the human being is inviolable. Therefore, the denial of human rights is not only an individual and personal tragedy when it happens, as we will see later today when we get into particular stories by the other presenters, but also creates the conditions of social and political unrest and ultimately sowing the seeds of violence and conflict within and between societies. The history of human rights has been shaped by the struggle for dignity, freedom, and equality. While the modern idea and social expectation of international human rights was established in response to World War II, the concept of human rights can be traced through all major religions, cultures, and philosophies throughout recorded history. Spiritual beliefs often inspire understanding of human rights, and the origins of many human rights provisions can be traced to religious documents. Early written spiritual sources address questions of people's duties, rights, and responsibilities. For example, Christ's teachings on behalf of the vulnerable, poor, and oppressed, and disenfranchised served as a model for U.S. policy and continues to inspire many contemporary human rights activists. Although many of us may be more familiar with Western traditions, modern human rights thinking is descended from many traditions, values, and beliefs. Ancient India established principles of civil rights in the 3rd century BC, where the protection of human rights was pursued as official policy, as was the happiness of the people, which we see today some countries in the UN development reports, they're actually attempting to measure now the happiness. And Bhutan is actually officially marketing itself as a country that puts happiness first. All citizens of all religions and ethnic groups have rights to freedom, tolerance, and equality. In addition, the unnecessary killing of animals was abolished in ancient India. And now, as we all know, the domestic law in the United States is addressing animal rights. Based on the concept of ahimsa, nonviolence, Gandhi, an attorney by training, organized millions against the oppressive and unjust British rule of India. Human rights also took place under Islam. Muhammad, in the 622, preached against what he saw as the social evils of his day, and he implemented social reforms that at their time were advanced. In fact, the legal status of women in other cultures, including the West, did not have the legal status that Muhammad addressed in Islam until many centuries later. He also drafted the Charter of Medina, which was a formal agreement to end war. In Africa, at that time it was tribal warfare. In Africa, the concept of Ubuntu is a belief that there is a universal bond of sharing that connects all humanity. This traditional African concept is seen as the founding principle of the new South Africa that recently threw off the chains of apartheid and elected Nelson Mandela, an attorney who spent 30 years in jail, president. The South African Constitution has adopted, incorporated many of what is now considered the body of international human rights, including being one of the first countries to put in writing an attempt to honor very basic economic, social, and cultural rights, including the right to water. The right to water was actually recently upheld by the High Court of South Africa, confirming that water is life and sanitation is dignity. Law codes which set rules, exact punishments, and attempted to minimize the exploitation of the weak by the powerful have existed since ancient times. The oldest written codes are found in Samaria, but it was the Persian Empire of ancient Iran that established unprincipled concepts of human rights in the 6th century BC under Cyrus the Great. Cyrus declared that all citizens of the empire were free to practice their own religions and beliefs, and declared that men and women had the same rights. He also abolished slavery and built all the palaces of the Persian Empire with paid labor, in a time when slaves typically did all the work. Cyrus also freed the Jews of Babylon who were in slavery so they could return to Jerusalem and build their temple. The Cyrus Cylinder today is recognized by many as the world's first human rights document. It was actually written for a card. In modern times, Mohammad Mossadegh, with a PhD in law, became a prime minister of Iran, leading a democratically elected parliament. As Iran's founding father of democracy, Mossadegh attempted to end exploitation of Iran by the British by canceling all the oil industry concessions. He advocated for Iran's right to do this at the Security Council and at the International Court of Justice. While the Cyrus Cylinder is now on display at the UN headquarters, the people of Iran are again in the streets demanding that their rights be respected and protected. I guess that's just a little example of how we have the ability to respect and honor human rights changes over time and changes from place to place. The rule of law, of course, is fundamental, and that's why we're here today. The rule of law is fundamentally important to the protection of human rights. Magna Carta, which was adopted in 1215, is considered one of the most important legal documents in the history of democracy. It required the king to denounce certain rights that he felt he had, to respect legal procedures, and accept that his will could be bound by law. Oh. Okay, I would just like to finish this one thought. The rule of law led to the constitutional rule of law today and such important principles as habeas corpus. I would like to ask that Dr. Kia come and welcome you now that he's here, because I know he has a class. So if you don't mind, I'll interrupt my presentation. And welcome, Dr. Kia.
Going to go in front of the audience. I'm going to stand next to my dear friend and colleague, Professor Paul Loren, and just welcome all of you and tell you how happy we are that this event is taking place. Express our special appreciation to the law school, Professor Barry Bird. Thank you very much for all your support, and to Dean Irma Russell. And it's really a privilege to see some of you. I know some of you, some of our distinguished scholars here. So no interruption. Thank you very much, Andrew. Just welcome from international programs. Thank you very much.
So some technical questions. Can everybody hear me okay? Yes. Okay, great. Okay, now we can get to my favorite part. No. People have organized for meaningful access and enjoyment of human rights. The major revolutions of the 18th century, the United States in 1776 and France in 1789, were based upon the notion that people are naturally free and equal and entitled to inalienable rights. The French Declaration of the Rights of Man and Citizen is similar. However, it includes both individual and collective rights of the citizens and the idea that the rights are universal, not just for French citizens. The Geneva Conventions of 1864, which laid the foundations of international humanitarian law, are the international community's first attempt to define laws of war, and also some of the first attempts of organizing as an international community to create laws itself. Nearly all countries have ratified the Geneva Convention. Nearly all countries have ratified the Geneva Conventions. Maybe we don't all follow them. And millions work to address these first commitments under the leadership of the International Red Cross. The International Labor Organization was also established and mandated to protect and promote people's rights, in large part to work. It was Dr. Oyvind Ravna, who I think has arrived, will mention the impact of the ILO conventions, particularly ILO 169, on the right of indigenous peoples in their negotiations with Norway. The League of Nations was established in 1990 at the end of World War I with the goal of preventing further war and believing in settling disputes between countries through negotiation. One of its main tasks was to assist and support countries in their transition from colonial rule, a task which the world continues to face, and then we see quite a response to maybe the failure to address the impact of colonial rule on countries throughout the world. Even before women could vote in the United States, they traveled by ship to The Hague to discuss and advocate for the end of war. They formed an international women's organization that exists today and maintains consultative status with the United Nations. Both Jane Addams, who is the president and is in this picture and was in the previous picture, and Emily Greenwald, who was the international secretary, received the Nobel Peace Prize for their work, not only in advocating for peace, but bringing people together. In 1915 is when this group of women went to 1915 at the end of World War I. At that time, they made the connections that in order for the same connections that Eleanor Roosevelt made later, that you needed to end poverty, you needed to have equality, you need to develop properly in order to prevent war. You needed to honor human rights. Throughout the world, the champions of human rights have most often been citizens who have played a cardinal role in focusing the international community on human rights. The international women's movement succeeded in gaining for many women the right to vote. Through their participation, continued to greatly influence the international human rights agenda. The agenda set by women as early as 75, but which was put in the forward-looking strategies in Nairobi and the platform of action in Beijing in 1995, around the three main principles of equality, development, and peace, are now the main foundations for what the international community has decided is of the utmost security threat, and developed the Millennium Development Goals to try to address these. And one of the things was making sure that women were empowered to participate in societies, to educate their children, and to eradicate poverty itself. NGO activities surrounding the Beijing conference drew unprecedented attention to the series of violations of human rights against women, which both Ishao and Rebecca were, and from want. The turmoil and atrocities of the Second World War and the growing struggle of colonial nations for independence prompted the countries of the world to create a forum to deal with the world's consequences. The United States and England had already agreed to the basic principles to end World War II without colonial expansion and to honor self-determination of peoples. And the lessons of the Great War were heavy in mind, making it easy to recognize the connections between local and international security. When the United Nations was founded, it was founded by a treaty that affirmed within its document the human rights and the dignity of all peoples. This is in the charter. Human rights were cited in the founding charter, agreed to by all member states as central to the UN's purpose. Although the UN's first adopted resolution was for the elimination of atomic and other weapons of mass destruction, the UN quickly turned its attention to, well, not as quickly as I am, to the adoption of the Universal Declaration of Human Rights. It is translated into more languages than any other document, and is the foundation of international human rights law. And although the members varied in their ideology, their backgrounds, their religions, their cultures, and their political systems, the value of inherent dignity continues to impact people's lives all over the world. You know, we agreed not to have bells, but I think I am running out of time. So, human rights are I just want to go, the foundation of human rights, I do want to mention, is the Universal Declaration in and of itself is not law, but it was put into 2 conventions. At the time of the Cold War, it caused the Universal Declarations to be split into the International Covenant on Economic and Social and Cultural Rights and the International Covenant on Civil and Political Rights. The United States did ratify the International Covenant on Civil and Political Rights in 1992, and even though some of the provisions of the Universal Declaration are found in both documents, you can tell by the titles that many of the rights that people continue to fight for today, such as health care, are not that are considered a international human right, are not ratified by the United States at this time. It also became the foundation to many other human rights treaties. Of course, the one we should talk about a little bit today is the Convention on the Elimination of All Forms of Discrimination Against Women, CEDAW for short, which there still is a movement in the US Congress for us to ratify this convention. We have ratified the Convention Against Torture, but many of these things I'll leave to my colleagues to discuss, the enforcement, the applicability enforcement of all these documents. And then we have lots of declarations. International law, which actually in many ways was first started to justify the taking of Indian lands under the doctrine of discovery. There is now a UN declaration attempting to recognize the rights of indigenous people and to, in many ways, international law has come full circle to get at what the point of my discussion is the inherent dignity found in everybody. I believe that the development of international human rights law is just answering the question, what more do we need to understand about the dignity of ourselves, of what it means for us to be human and to want to live in this world. In conclusion, it's true that every government today continues to violate the rights of their citizens, and the citizens challenge them and ask them, confront this injustice and inhumanity, asking their governments to honor and protect and promote and to provide these kinds of human rights. Most recently, in many ways, something that's changed dramatically in my lifetime is when I was in law school, Bowers v. Hardwick was passed, which was a law which the Supreme Court at that time said that states could decide whether or not to discriminate and actually criminalize homosexual relationships. Within a relatively short period of time, they essentially reversed their decision, saying that the religious principles and the values that they stated were at the heart of Bowers v. Hardwick were not only in fact false, but that if they're going to use Western values, then it was very important for them to look to Western values. And they actually referred to the European Court of Human Rights and their view on saying that it was against any country in the European Union's, it was against their policy and against the law to discriminate against homosexual activity. In conclusion, now we see human rights and development coming back together. I'm just going to skip. The monitoring, will you guys be discussing the monitoring? Briefly, okay. So I'm going to let others, this is what the system looks like. There's all of these bodies that do lots of different things to promote human rights. And we will just have a little bit of example in the next 5 speakers. So thank you very much. I do have a link for the for a lot of the human rights documents. I've attached, it's back there, sorry. Did everyone get it? There's a handout. Okay, thank you, and thank you for your commitment to this.
Okay, is that all right for you back there? Okay, so let's first just talk a little bit about what international law is so that we can understand how international human rights fits into it a little bit better. What international law is not is foreign law. So if you think of, for example, the law of Norway or the law of Mexico, that is not international law. That's foreign domestic law. And sometimes there's a confusion there. Most foreign laws, like our laws, are affected by international law and interact with international law. But international law is a legal system above and beyond domestic legal systems that interplay with domestic legal systems. Also, a lot of people commonly hear that there's public international law and there's private international law. And what public international law is generally termed to be is international legal rules that apply when 2 different nation states, and in international law, the term states refers to a nation state, are interacting. So the formation of a treaty, the formation of customary international law, this is generally termed public international law. And private international law is generally the rules that apply when there are individuals or corporations, so private actors, interacting where there's more than one state involved. So if a French plaintiff, for example, sues a US company in French court, that is private international law. And this is a distinction that has less of a difference as time has gone on, because we have more and more treaties which are created between nation states impacting private international law. And we have more and more individuals and corporations taking part in the formation of public international law. So to the extent that there is still a distinction, it is one that's definitely decreasing in importance. So generally, international law is defined as a consent-based system of law that regulates the conduct of nation states and also has an impact on individuals and corporations, private actors, where there's more than one state involved. It's really important to emphasize that this is a consent-based system of law. So the reasoning goes, one of the privileges of being a sovereign nation state is nobody can tell you what to do within your own physical territory. You have a sovereign right to do what you will within your own territory. And one of the results of this is you can't be bound, you can't be obligated to do or not do something as a nation state unless you consent to be bound. And this consent-based system becomes really clear when you start to look at what the sources of international law are. And there are 2 main sources, the first being treaties and the second being customary international law. A treaty is essentially a written agreement between two nation states binding themselves to a certain type of behavior, so to either do a thing or to not do a thing. And we have what you've probably heard of as a bilateral treaty, and a common example would be an extradition treaty where one state agrees to send back foreign nationals to be tried or to live out prison sentences back in their home state. And this is just an agreement between two countries where they're agreeing to basically reciprocity or reciprocal treatment with each other. Another example is foreign investment treaties. There are lots and lots of investment treaties between countries where they are both agreeing to work together to a mutual benefit for foreign investment. Then you have multilateral treaties, and this is really where you see international human rights treaties. Multilateral treaties are treaties between more than two countries. And these can look very different. They can take a long time to negotiate. They're usually negotiated through ministries or through the State Department, for example, whatever agency is committed to diplomacy in that country. And they usually come together and talk about a draft. They have committees that will deal with drafting certain provisions of these multilateral treaties, and they'll come together on a regular basis to try to move drafts forward until everybody is generally happy with the draft. And this can take a really long time. A common example is the Law of the Sea Convention, which took over 10 years to negotiate and to ultimately get into a final form. So once a treaty is entered into force, it is binding law for those countries who have ratified it. So through this consent to be bound, through ratifying this treaty, law is created for those parties of the treaty. But keep in mind that that law is not binding on people or on countries who have not entered into that treaty. So if you haven't ratified a treaty, you're not bound by its terms. Unless, of course, the treaty represents customary international law, which is the second main source of law. And customary international law occurs when you have many states that are basically doing the same thing. For example, when you have a number of states who are making torture illegal, who are not condoning torture. And importantly, they are making torture illegal or prohibiting it because they have a legal obligation or they feel a legal obligation to prohibit torture. So there's really two prongs to creation of customary international law. The first is that you have this repeated state practice, many countries doing the same thing or not doing the same thing, based on this sense of legal obligation. So for example, it's customary international law that in a time of armed conflict, you must separate or distinguish between civilians and non-civilian and combatants. You can't treat civilians like combatants. This is something that countries generally do. They generally feel legally obligated to do this. And it's really common that most customary international law is codified in a treaty at some point. But in the same way in our country, how you might have case law that deals with a certain legal rule and a statute that essentially sets forth the same legal rule, they are still separate legal rules and separate sources of international law. But customary international law sounds a little bit more complicated when you step back and you say, but this is supposed to be a consent-based system. How are you consenting when customary international law is being formed? And the idea goes that these countries who are doing this state practice are impliedly consenting to the creation of this legal rule by not torturing because they feel obligated. So you have treaties with this explicit consent as a source of international law, and customary international law with this implicit consent. You also have a third source of international law, which is commonly termed jus cogens, or peremptory norms of international law. And this is an exception to this rule that you need consent in order to have the creation of a legal rule. Because a jus cogens norm, or a peremptory norm, is one that is so fundamental to a universal conscious morality of the world, that it transcends sovereignty. So for example, no state can legalize slavery. No state can allow slavery officially within its borders, because the right to be free from slavery is a jus cogent norm. And so whether or not there is customary international law, which there is, or whether there's a treaty, which there is, it doesn't matter. You can't condone slavery, period. So there are certain things that are more important than sovereignty, so the story goes. So as you all know, human rights is just one subset of many different areas of law in international law. You have the law of armed conflict, you have the law of business and trade, of air and space. You have numerous, endless areas of international law that human rights is just one of. But human rights is a really, really important area of international law for a number of reasons. It was actually human rights concerns that led to what we now term modern international law after World War II. The world was reeling from the human rights abuses of the Holocaust, and it was this need to make sure that that never happened again that pulled countries together to make sure that the UN was a strong force. And as Andrea mentioned, when you look at the Charter of the UN, and you see that it has specifically in Article 1 this reference to human rights and freedom from discrimination as being a really important principle, it's very clear that this is one of the impetus, the main impetus for human rights in the last 60 years, or for international law in the last 60 years. But we have sovereignty, and there's an inherent tension in this bedrock principle of sovereignty in international law and international human rights law, because sovereigns don't want to be obligated to do or not do a thing unless they're bound. This principle that I can't be told what to do by an outside source or by another country is really important in international law. Human rights is not concerned with sovereignty, it's concerned with individual rights, and the idea that no matter where you are, you have certain protections from your government that nobody can derogate from. So on the one hand, you have this sovereignty interest, and on the other hand, you have this individual interest. And that's why, for a long time, international human rights was really a lip service, non-binding type of a thing. You had it in the Charter of the UN, but the Charter of the UN really didn't set forth any concrete obligations for the members, just this general sense of having to observe human rights and observe individual dignity. And then you had the Universal Declaration, like Andrea mentioned, in 1948. Again, we can be proud that Eleanor Roosevelt was a big part of this. She went all over the world talking with scholars and lawyers in Western and non-Western countries, trying to come up with a floor of universal norms and universal protections that all people were entitled to. But this wasn't a binding document, and it wasn't binding because states weren't ready to be bound to very specific human rights obligations. States were fine with signing on to something that said these are good things, but they weren't fine yet with saying, I'm going to ratify a treaty obligating me to follow this human right with a threat of a breach, a treaty breach for noncompliance. And keep in mind, in the US, this makes sense. In 1948, when we had this Universal Declaration, women had only been allowed to vote for 30 years. We were still separate but equal. We had a long way to go toward ourselves being able to show that we could follow the obligations that were set forth in the Declaration. So what were these obligations? Andrea mentioned some of them. They basically fall into two categories. The first, political human rights that are commonly termed the first generation of human rights, the most important. And this is the right to life, the right to liberty, the right to freedom of person, the right to be free from arbitrary detainment, the right to be free from ex post facto laws, the right to due process, all of these essential human rights that we as Americans understand, and because we have them as Americans. based on our Constitution and our Bill of Rights. The Declaration also set forth this second generation of human rights, often termed the economic, social, and cultural rights. The right to Social Security, the right to a fair wage, the right to holidays, right? All of these, they're important, but they're not quite as important as being free from arbitrary detainment. If you had to go make your choice, you're going to choose to be free from arbitrary detainment rather than to be free, rather to get Social Security. And it was because of sovereignty and because of this concern about countries being bound to explicit obligations that it took 30 years for us to actually get some binding treaties codifying the rights set forth in the Declaration. So, as Andrea mentioned, we had the International Covenant on Civil and Political Rights that didn't enter into force until 1976, 10 years after it was finalized. And the International Convention on Economic, Social, and Cultural Rights, again, didn't enter into force until 1976. So we had a big span of time in which we were thinking these rights are good, we want to talk about these rights, but states weren't really willing to sign on the dotted line and ratify these treaties. So these treaties did a couple interesting things. They basically set forth two types of human rights. The first are protections that are commonly termed prohibitory obligations. So what they're doing is they're prohibiting a government from doing a thing to you. So the government may not infringe on your freedom of speech, may not discriminate against you. And the other type of right is an affirmative obligation in which a country must provide you with something, must provide you with due process, for example. Another interesting thing these treaties did was set out a difference between absolute human rights and conditional human rights. So there are certain human rights that can't be derogated from at any time for any reason, period. And these are the rights that we've talked about: slavery, the right to freedom of person, the right to be free from arbitrary detainment, the right to be free from unconsenting scientific experiments done on you, the right to recognition before law. And the rest of the human rights set forth in these treaties were what were termed conditional rights, where a country could circumscribe the rights for a certain period of time if there was a public emergency. And so they were thought to be a little less important. They're not absolutely guaranteed. They're conditionally guaranteed as long as everything is going okay in the country. And also, these conditional rights can be circumscribed if the fundamental freedoms of others require that they be circumscribed. So, for example, your right to freedom of religion can be circumscribed if it's necessary to prevent a practice, to prevent oppression of women based on that practice. So despite the fact that we had this inherent tension between the individual and protections of the individual in international human rights, and this sovereign concern that you can't tell a state what to do in its own borders, we do now have many, many binding treaties, as Andrea mentioned, in pretty much all areas of international human rights. Right now, one of the nascent areas of human rights where we don't yet have a binding treaty is the rights of gay and lesbian people. And there is a declaration that was put forth on the UN floor last year, and we saw a lot of pushback. For example, the Organization of Islamic States, they had an official statement rejecting this declaration of gay and lesbian rights. And the reason that we had this official statement, right, there's no reason to really do that unless you just want to make a point, unless you start to think about customary international law. So if more and more states are signing these declarations and more states are guaranteeing gay and lesbians' rights within their own countries, then you have the formation of customary international law starting to form. And what we have is this persistent objector rule in international law. If a country persistently objects to a right that is being formed in customary international law. If it ultimately becomes customary international law, those states that persistently objected are not bound to follow that law. So going back to our consent-based system, the Organization of Islamic States said, wait a minute, we don't believe that there should be equality with gay and lesbian rights. We're going to continue to officially voice our objection to this, so if it ends up becoming customary international law, we're not going to be bound by it. There's another reason why we've seen a proliferation of human rights in recent years, despite this traditional sovereignty-based paradigm in international law. And that's because we have a lot of new actors in international law. We have international organizations like the UN, but my view is that those types of organizations are useful, but they're not really that useful because who are their members? Their members are states. And what are their state members interested in? Preserving their sovereignty. So there's always going to be this sovereignty issue, even in international organizations, holding back the proliferation of international human rights. But what we do have are non-governmental organizations that have taken off in the last 15 and 20 years. And non-governmental organizations don't have any interest in sovereignty. What non-governmental organizations have is an interest in forwarding whatever group's interest is that they're advocating for. So Human Rights Watch, Amnesty International, Committee of the Red Cross, all of these groups don't really care about whether or not they're impacting sovereignty. What they care most about is protecting women and children, protecting prisoners of war, protecting civilians in armed conflict. And so it's this new group of actors in international law that has forced a lot of hard questions out into the world and has really shaken up the dynamic and made international human rights law the forefront in international law where it hasn't been before. And also we have the individual, who has an increasingly important role in international law where that hasn't actually been the case before. Before, in traditional international law, if I had a claim of a human rights violation, my country would have to bring that claim before an international tribunal on my behalf. So my right was really a derivative right. But now we have a number of tribunals in which individuals themselves have standing to bring claims for redress based on human rights violations. One of the most important is the European Court of Human Rights. Any individual can bring a claim that one of the sovereign nations of the Council of Europe has infringed upon one of their rights set forth in the European Convention of Human Rights, which codifies most of these basic human rights. And the court has a backlog now because there's so many hundreds of thousands of cases being brought. Also, we have the Human Rights Committee, which is charged with hearing individuals' complaints against members of the International Covenant on Civil and Political Rights. So again, you have this tribunal in which individuals have standing to bring claims against sovereign nations. And increasingly, you have national courts that are allowing individual plaintiffs to bring claims based on statutory law that it was created to codify international human rights protections, such as the Torture Victim Protection Act or the Alien Tort Claims Act. So there are a lot of different tribunals in which the individual can now bring claims for international human rights violations. And this itself is also really changing the playing field of international human rights. I think one of the continuing issues with international human rights today is that it's trying to create this universal floor of protections for individuals across a wide, disparate range of legal systems. And when we think of international human rights, really it's kind of a Western concept. It has been addressed in different codes and different non-Western societies throughout time. And Andre is completely right that, for example, Muhammad definitely made the world better for women in the Arabian Peninsula than it was before. But we have to ask ourselves whether or not it's possible to take this Western individual rights-based approach and translate it across the world into cultures that might not have the same ideas that we do about individuals being the ones that have the rights, being the right holder. And so, for example, we see in CEDAW, what Andrea mentioned, the Convention on the Elimination of Discrimination of all forms of discrimination against women, we have a lot of reservations. And a reservation is something that a party can insert into their treaty obligations and say, I'm not going to be obligated to this specific provision of this treaty, or my obligations based on this treaty are subject to this caveat. And so, for example, Saudi Arabia had a blanket reservation on CEDAW and said, if there is a conflict between Islamic law and the obligations set forth in this treaty, Islamic law is going to be what we apply. And so this is potentially problematic if Islamic law as applied in Saudi Arabia is actually in conflict with some of the rights set forth in CEDAW, which arguably it is in some ways. And there's two schools of thought on what we think about these reservations. The first school of thought is, it's okay. We want to get these treaties as ratified by as many countries as we can, because all of these ratifications and all of this global support is going to ultimately forward the human right that is the fundamental essence of the treaty. And there's another school of thought, which is, this is completely undermining the functionality, the efficiency, and the validity of this treaty. What's the purpose of having an underlying universal group of norms toward women if a country can sign on to it and say, but we're actually not going to apply it if it doesn't comport with our own cultural beliefs toward women or our own religious beliefs toward women? So there's a lot of interesting treaty practice that you see with international human rights treaties that you don't necessarily see with other types of treaties in international law. And it is tricky to try to create this universal floor, which is really what international human rights is trying to do. But there is no doubt that, especially in the last 30 years, we have seen an incredible increase in international human rights as a field that's on everyone's mind, that scholars are taking more and more interest in, that you're seeing in the media more and more, and that is becoming a more and more important part of international law as a whole. And it is bettering people's lives in small ways and incrementally throughout the world. Thank you.
Good afternoon. I'm Sally Cummins. My bio tells you that I worked for 25 years for the U.S. State Department, and I can't tell you how many times in that 25 years somebody said the same joke, which goes something like, international law is an oxymoron. There is no law in international law. And I think people say that for a couple of reasons, and now I'm thinking particularly about Americans. Part of it is a discomfort with the customary international law and jus cogens that Anna was just describing to you. That's often characterized as, oh, you just make it up as you go along. I can tell you that you can't make it up as you go along. If you're in an international tribunal, it's a rigorous exercise of analyzing whether something has really gain the status of customary international law, but it is simply not something that we are used to dealing with. As there have developed more and more treaties, I think this becomes international law becomes a little more comfortable, because there you have it in black and white. There's even usually some sort of negotiating record. You can go to it to find out what people were talking about when they came to agreement on particular terms. So that aspect, I think, is beginning to be a little more comfortable. But the other thing that Americans often mean when they say there's no law is that we do not have a system on the international plane to enforce implementation, to provide reparations. We do have a lot of places on the international level that address these issues, but there's no uniform system as we have in the United States and in many countries. You don't have international police, or you don't have permanent courts in the layered way that we do. As Anna said, there is the issue of sovereignty. Sovereign equality of states constantly comes up in international law, and a sovereign is not subject to any court or tribunal to which it has not agreed, with two exceptions, which you'll see in a minute. So there is a lack of overall system for enforcement in the international plane, and what I'm going to try and talk to you today a little bit is both why and how implementation occurs anyway, and also what is out there. Maybe this helps. What institutions are out there? Down here, Peggy? Peggy is the authority here. Maybe not so close. Oh, okay. Is that better? Good. To try and give you some feel for how things are implemented and enforced. My first thought, and Anna and I have taught sometimes together, and we both end up saying the same thing, so I'm glad she didn't say it this time, is that under U.S. law, most of us don't obey the law because we're afraid we're going to get caught. We do it because we agree with the law, or because we think it's useful to keep society running, or because it's in our self-interest and we expect reciprocity, or all of those reasons. Just a simple example. When I come to a busy intersection, if there's lots of traffic at least, I don't run that red light because I'm afraid I'll get a ticket. I obey that red light because I don't want to get in the middle of the intersection and hit somebody or somebody hit me. And this is really, it's a very simple example, but it really is a lot like what happens on the international level, especially as we get to have more and more treaties that have been negotiated by, if they're negotiated under the auspices of the United Nations, you're going to have 193 countries that can show up and participate. This means they have some sort of vested interest. They have some hands-on understanding of what this treaty is supposed to do. And when they decide whether or not to become a party, they are deciding, we hope, whether they intend to live up to the obligations. I can tell you, as a practicing lawyer in the U.S. government, and I'm not saying there aren't violations, but we don't enter into treaties that we don't think we can actually implement. And we spend a lot of time getting the implementing legislation always before we ratify a treaty. So it is a serious approach. And a lot of international law serves, again, the self-interest of countries, nations, and is something they expect to have reciprocal treatment for. This is certainly true in a lot of areas of customary international law. We protect the diplomats and their embassies in the United States because we expect other countries to protect our diplomats and our embassies in those countries. Without diplomatic presence, at least we who believe in diplomacy think, you wouldn't have the ability to have ongoing international relations. And to show you how deeply we believe that, the United States still holds the embassy of Iran in Washington, D.C. for Iran. This is 33 years after the revolution, almost that long since we broke diplomatic relations. But we don't think we can just make that our building. It'll be there someday when Iran and the United States hopefully restore diplomatic relations. But we do have violations. So Anna mentioned a couple of ways that individuals can get redress for violations of international law. And the first of these, I'll start with, this is the first one she mentioned, and that's in national courts. An individual can bring suit in the United States or in the national courts of many countries for a violation of international law. You saw this certainly in issues relating to the detainees and what we used to call the war on terror. You notice we don't say that anymore. But this resulted, for instance, in the Supreme Court decision, Hamdan, that held that Article 3, which is common to all 4 of the Geneva Conventions on the Law of War, applies in the United States, applied to the detainees on Guantanamo, and further that the military commissions, as they existed in 2006, violated our obligations under that treaty. And therefore, we couldn't go ahead with trials on those military commissions. They've been modified since then. So it's a very simple but clear example, I think, of what national courts can do. The big problem with national courts is sovereignty. And under a doctrine called sovereign immunity, one nation's courts cannot exert jurisdiction over another sovereign nation unless that nation agrees. Now, there are some exceptions to that doctrine. Probably the most common one is when that nation is involved in commercial activities. It's one thing to say that a sovereign can't be brought before a nation's courts for governmental actions, but it's quite another to say that if a country owns an airline, Boeing can't sue that airline for violation of a contract. So that's the commercial exception. And I'll come back to this in a little bit because we've had quite a development in that area just in the last 2 weeks. So national courts will get you part of the way, but not all the way. On the international level, Andrea mentioned the UN, the High Commissioner on Human Rights. You may have seen her, Navi Pillay from South Africa. She appeared in an impassioned plea just last week or earlier this week before the Security Council, trying to get them to take action to protect civilians in Syria. Her office is important, but she is only one part of a whole system of committees, special rapporteurs who can investigate allegations of violations in particular countries, look at particular issues. The most important committees come out of these very fundamental human rights treaties that both Andrea and Anna have mentioned. Every one of these, the Treaty on Discrimination Against Women, on Rights of Child, on racism, on torture, and the broad civil and political rights and economic, social, and cultural rights. Each one of these treaties creates a committee in the UN with powers to monitor implementation. And each country that signs those treaties, that ratifies those treaties, is obligated to submit periodic reports. Now that may not sound like much, but I've worked on those reports and for the United States, and I can tell you, you sweat blood over them. It's an interagency process. It takes a long time to put together one of these reports. We do them I think under most of the treaties, it's about 4 years. But it's a very interactive process. We submit it to the committee in Geneva. They come back with questions. This goes back and forth, questions and recommendations and criticisms, you can be sure. Eventually there is a oral proceeding. We avoid calling it a hearing. Another key issue at these committees is something Anna mentioned, and that's the power of the non-governmental organizations. Because non-governmental organizations have a key role in the committees. They can even file shadow reports, and they do. So the United States files its report. There may be several NGO reports that get filed. The committee has a lot of information to look at, and all of this promotes implementation. Nevertheless, we still need tribunals. And the UN Charter, I think, once again, is the place we have to start. The UN Charter in Article 2 repeats this importance of the sovereign equality of nations, so you know we're going to have to deal with that. But the Charter creates 2 bodies with legal power. The first of these is the Security Council. The Security Council has very special powers to maintain and restore peace and security, international peace and security. And when they act under that power in Chapter 7, and you'll hear this referred to sometimes, the resolutions they adopt have the force of law. The most common way we think of them exercising those powers is by imposing sanctions and authorizing the use of force. It's one of the two ways the Charter allows you to use armed force. Libya is a good example last year. First, there was a resolution authorizing sanctions, and not too long after that, there was a resolution authorizing use of force, and that's when NATO went in. But in the 1990s, the Security Council got more creative, and twice they established tribunals, criminal tribunals. Now, once you start talking about criminal tribunals, you are, of course, talking about individual responsibility, not the responsibility of a country, but you might be talking about the president of a country. And ordinarily, sovereign immunity, also there is head of state immunity. Ordinarily, at least the sitting head of a country cannot be brought before a tribunal without the country's agreement. But in this case, first for the former Yugoslavia and second for Rwanda, the Security Council set up criminal tribunals very specific to a time and a situation. It was the breakdown of the former Yugoslavia and the atrocities during that period after 1991. And in Rwanda, it was the aftermath of the 1994 genocide. So that's the subject matter of these tribunals. The only crimes they could look at were genocide, crimes against humanity, and certain war crimes, but you can cover a lot of ground. And notice this is all human rights and law of war oriented. And those countries had no choice. Because the Security Council was acting under that particular power, Rwanda and Yugoslavia weren't asked whether they agreed to participate in this tribunal. And you may remember, for instance, when President Milosevic was being tried in The Hague. He died before his trial was finished, but there was a former head of state brought to trial for serious human rights and law of war violations. The other body with legal powers that the UN Charter created was the World Court. Its formal name is the International Court of Justice, ICJ, but most commonly referred to as the World Court. It is the only permanent court of worldwide jurisdiction that can hear claims between two nations, but you still have sovereignty, sovereign equality of nations. And the UN Charter, I've always thought this was a political decision. Instead of saying that you automatically are subject to the jurisdiction of this new court that we haven't really quite created, but we're going to, they left decisions of jurisdiction to the countries. And again, I think it was because they wanted to make sure that people signed on to, became parties to the UN Charter, and didn't want to have this very contentious issue get in the way of having people really become members quickly. So there are three ways a country can become subject to the jurisdiction of the World Court. One is to accept very broad jurisdiction over pretty much any violation of international law. The United States did that at one point, and then in the 1980s, we terminated our acceptance of that broad authority. It was in the context of a case brought by Nicaragua against the United States for its involvement with the Contras. All I can say is this was the time of Iran-Contra. There were a lot of funny things going on in our government because I have always been very sorry that we terminated that acceptance. On the other end, two countries or several countries can agree to bring a very specific issue to the World Court. That's also provided for in the court statute. The United States and Canada did this, for instance, in asking the court to resolve a boundary issue relating to the Gulf of Maine. And And then in the middle, and the third way the court's statute suggests is that treaties can provide for jurisdiction in the court. So many treaties will have, and certainly every human rights treaty, I think, at least the ones under the UN, will have in one of its final provisions that if countries have disagreements as to the meaning, interpretation, application of this treaty, they should try to resolve it through their own means, through arbitrations. But if they can't, then they agree to take it to the World Court. The United States pretty consistently takes a reservation to that agreement. We are still party to many treaties where we have agreed to go to the World Court, but in recent years we have usually taken a reservation, and that is allowed under international law. So that does hamper the court's jurisdiction, obviously. I mean, that's a statement. But about a third of the countries, I think, that are now members of the United Nations do accept the broad powers, and others do have some, the court does have some jurisdiction over almost all countries. One specific case I want to mention because it's so important in what we're talking about today, and that is 2 weeks ago tomorrow, the World Court issued an opinion that makes human rights lawyers very unhappy. We talked about national court jurisdiction and sovereign immunity. There has been a growing theory in recent years, probably, I don't know, 20 years, that if a country commits the most egregious human rights and law of war violations, things that rise to the level of jus cogens that Anna mentioned, which are just above and beyond anything that countries could ever agree were legal. If a country commits those kinds of violations, then it loses its right to sovereign immunity. There have been cases in the United States, most connected to World War II, where district courts recognized the theory and then courts of appeals overturned it. There have been different reactions in different countries. But Italy, a few years ago, issued several judgments against Germany. Italian citizens came into Italian courts still wanting reparations from World War II. And these were for massacres and for slave labor. So there was no question that these were the worst of the worst kinds of crimes. And Germany, before the World Court, did not argue that it hadn't done what it was accused of doing, nor that those weren't terrible crimes. What it did argue was that the Italian courts had violated its sovereign immunity. The Italian courts argued for this exception to sovereign immunity. The World Court decided there's no such exception. It upheld Germany's immunity in national courts. And since national courts are such a vital part of human rights enforcement, that is a real loss. It would have been better not to have the ICJ decision at all. But I read the court also as saying, the court's opinion, they talk about this is where the law is today. And I think they are acknowledging that we probably haven't seen the last of this theory, that it is the kind of thing that could develop as customary international law, I suppose, though sovereign immunity is so hard to really get around that would probably not be something that everyone would step into. The court also made a point of saying that the fact that they were upholding Germany's sovereign immunity in Italian courts did not mean that Germany wasn't responsible. And it considered it would be appropriate for the two countries to negotiate. So these Italians may yet get reparations. And by the way, Germany has paid a lot of reparations. So even to Italians, but these particular groups had never been covered. And maybe that influenced the court a little bit too. I'm not sure. There is one other court on the truly the world's wide spectrum, and that is the International Criminal Court. It is relatively recent. It was established by a treaty in 1998. So treaty, every country has, who signed. Did somebody? No. Every country who becomes a party to the treaty agrees that its nationals can be brought before the International Criminal Court. This court is actually very similar to those tribunals that were set up by the Security Council for Yugoslavia and Rwanda. Same, limited to the same crimes: genocide, crimes against humanity, and war crimes, although it has a broader war crimes mandate. This criminal court can also hear violations of crimes of aggression, but they couldn't, when they were negotiating it in 1998, they couldn't decide on a definition of aggression, and the court still hasn't come up with a definition of aggression, so it can't do that until they get the definition settled. But it is, the court is up and running. It has completed at least one trial. These are huge undertakings, you know, to set up whole new courts. It took until 2002 to even get enough countries ratifying, I guess, the treaty for the court to come into force. But there are now 120 members. The United States is not a party to the International Criminal Court. At the time, we objected on several grounds, and although we are now in a better working relationship with them than we were for a period in American politics, we still have not agreed to be a party. It provides, as I said, that the court can have, the treaty provides, that the court can have jurisdiction over the nationals of any country that becomes a party. Fine. It says that another option is the Security Council, under maintaining or restoring peace and security, can refer a matter to the court. That's also fine. And that happened most recently, again, with Libya. Libya, I have a friend who supervises the office that includes Libya, and she said, you know, by the time this is over, Libya will have put us through every aspect of public international law there is relating to nations. Toward the end, the Security Council referred the situation in Libya to the ICC. I think it was Gaddafi, one of his sons, and a couple of other officials. So what we object to is that there is a possibility in the treaty that the prosecutor could institute an investigation on his or her own of a violation in a country that's a party, and that people from countries who aren't parties could still be brought in under that investigation. So we said that violated international law. Perhaps more troublesome, and I don't know, I'm not an authority, but it's a very interesting issue. If the the light's on, there it is. If the ICC is supposed to try people, as it is, and all the way up to head of state again, when national courts are unable or unwilling to take action, then it would appear that would preclude something like what South Africa did, the decision to resolve and move forward using truth and reconciliation commissions. So that was another one of the theoretical objections. Another one was that brutal dictators, yes, you'd like to have them prosecuted, but the only way to get rid of them peacefully may be to promise immunity, that might be the final thing that would get them to leave. And about a year ago, I was looking at these lists again, and I was saying, oh, we probably don't even say that anymore because, after all, you do want everybody to be prosecuted. And then we got to the end of the situation in Libya and what was going on. They were trying to get Gaddafi to leave. Maybe that would stop the fighting quicker. But he had already been referred to the International Criminal Court. So if they were to find a country to give him safe haven, they had to make sure it was a country that wasn't a party to the International Criminal Court, because if it was, it would have the obligation to turn him over. I mean, this was really an unseemly kind of analysis that was going on very visibly, at least, in the New York Times. So I don't know. It's a lingering issue out there. My own, as I say, in this administration, the United States has re-engaged in, not in being subject to the court, but cooperating with the court, providing evidence, and that sort of thing. So I'm not sure. I suspect that at some point in the future we will become a party, but I don't know. There are other ad hoc criminal tribunals that are set up between a country with, in cooperation with the UN, and some of those have been very successful, and you're going to hear about one of those later this afternoon in Sierra Leone. Then I just want to say generally that there are all kinds of other ad hoc tribunals that are set up. For instance, a peace treaty may very well, 2, 3, 4 countries, they may very well agree to set up a tribunal just for the purpose of resolving issues left over from the hostilities. There are also, there are many tribunals that deal now with trade issues. There's the whole system under the World Trade Organization, then the North Atlantic Free Trade Agreement, NAFTA, also has to have tribunals, but they let each of them be set up on an ad hoc basis. In human rights, you're going to hear more. I'm very sorry that our Mexican participants couldn't make it today, but we are very lucky to have someone in Missoula who will be talking about the Inter-American Court of Human Rights. And I'm sorry, since I've been honest so far, the United States is not a party to the Inter-American Court of Human Rights, despite the fact that we are part of the Organization of American States. And I would just mention, Anna mentioned the European Court of Human Rights, and that's under the auspices of the Council of Europe, which has 40-some countries, so far broader than the European Union. And the African Union has an African Court of Human and People's Rights. That's a recent name, and I think it's very interesting because it so clearly reflects their view of collective rights. So with that, I think we are actually at break time, and then this afternoon, or when we come back, we're going to get some really much more concrete examples of what happens in human rights.
Although we didn't do very many introductions, I would like to specifically welcome Professor Ravna here from Norway. He's a visiting scholar here at the law school and at the Native American Studies program, and a friend. He comes a long way from a place that's in some ways similar and some ways in Montana. Thank you.
Thank you, Andrea. Yes, I'm very glad to have the possibilities to have this presentation here. And after my presentation, I hope I will receive some questions. I am asked to speak about the influence on human rights treaties on the Norwegian legislation impacting the Sami people. Before I go into the two topics, what I'm going to speak about, I have decided to divide it into two. The first is a general influence, or I'm thinking probably it's more correct to say influence on the Norwegian constitutional system from the international human rights treaties in relation to the Sami people. I have written up the two most important articles there, and I will come back to them. The next step, what is in somewhere more interesting, it's the particular influence of the protection of Sami rights to land and natural resources what is resulted from international treaties. And in that case, it's mostly the ILO Convention 169. Before I go into the topics, I'm not sure if all of you are familiar with the Sami people. So just some short geographical and anthropological topics. Here is the place where we find the Sami people. As you see, it's 4 countries: Norway, Sweden, Finland, and Russia. And I suppose in the past the Sami people was covering all of the Scandinavia, but today the Sami territories is defined from the middle of Norway, Sweden, and Finland up to the north. Finland, Norway, Sweden, and Russia is the traditional lands of the Sami, as I told, and it's not a big population or a big people. There is no any census anymore of counting the people, but you suppose there is between 50 and 80,000, and approximately half of them living in Norway. In Norway, the Sami people is recognized as an indigenous people according to the ILO Convention. In Sweden and Finland, this has not happened yet, but there is a process on the way. What's going on in Russia is difficult to say. There was a process in the 1990s to implement the ILO Convention, which will cover more than 40 different northern indigenous population. But that stopped in the 90s, and I think today, with the regime we have in Russia today, there is not a big hope that this process will continue. Little bit about the livelihood of the Sami. I think most of you have heard about the Sami as reindeer herders. And there is still a rather big group of Sami who is doing a nomadic reindeer husbandry, even if they are not living as nomads anymore. But when I say that they are doing a nomadic reindeer husbandry, it means that they are using the inland winter pastures and move the animals out to the coastline in the summer. The coastal fishery is probably a more important livelihood for the Sami people, both in the past and today. And there is just going on a legal discussion about to codify the rights, the historical rights to the Sami people. So far, the Norwegian government has refused to follow up a law draft or a proposal made by a law expert committee. A little bit about the history of the Sami, or the last year's legal history. There have been kind of a movement among the Samis in the post-war period. I suppose it was inspired by the general human rights development after the war. And it's also a fact that the Sami people got a lot of input from the American Indian movements here in US in the 1970s. The top of the development, or what we can say, conflict between Norway and the Sami people, it was in the end of the 70s when the Norwegian government decided to build an electric power station to dam up the Alta River. And the picture here is from the hunger strike in front of the Norwegian parliament in 1979. Then I will go into the legal topics. Reason to mention the Alta case, it was that even if the Sami didn't manage to stop the building of the dam, it resulted in a legal expert committee was put on who investigate the legal situation of the Sami. One of their proposal was to make an attachment to the constitution with a special article protecting the Sami language and culture. It's the responsibility of the authorities of the state to create conditions enabling the Sami people to preserve and develop their language, culture, and way of life. And I will use this article as an example of the influence of the international human rights development in Norway. This article was stated by the Parliamentary Constitutional Committee to be the most formal and binding form of a legal system can recognize and draw the consequence of the fact that the history of in Norway there have existed a Sami nation, or said in another word, that the Norwegian state is grounded on two different nations. If you look about the wordings again, so it's clearly that the article make a binding commitment, a positive binding commitment to create conditions enabling the Sami people to preserve and develop their language. Then we can ask where this come from. If you see on the preparatory works, which have a huge influence as a legal source in Norway, we can see that the Law Committee, the Sami Right Commission, had meant to give the article an understanding in accordance with the commitments in international human rights law. So the article was therefore designed on the model of the International Convention on Civil and Political Rights, Article 27, which we can see here. In any case, there is a huge difference in the wordings because the Norwegian constitutional article, it's formed in a positive way. It's a duty of the state. But the Article 27 is opposite. The state should not deny minorities rights to enjoy their culture. But in fact, this is not a big difference since the United Nations Human Rights Committee also have stated that that Article 27 means that the state is committed to arrange positive measures to take care of minorities' cultures. It's not only made in the model, but it's another interesting thing here. It's have to confirm with Norwegian obligations according to the Article 27, and it's intended to give a protection similar to the Article 27. And the link to the Article 27 means that the Constitution, Article 110, may change according to the development of the international law. And that's one thing particular with the kind of article or provision like the 110, who is not so strictly formed that it can be interpreted in according to a development of the international law. And in the preparatory works, which I quote from here, it said that it must be understood in such a way that it at any time shall fulfill the human rights obligation imposed to the Norwegian authorities. So that's a rather strong formulation, and it's difficult for the Norwegian authorities to escape from this provision, especially since it's a part of the Norwegian constitution. So when the Human Rights Committee interprets Article 27, it have also huge influence on the Constitution, Article 110A. So when the Human Rights Committee has stated that the protection covers the material basis for enjoying the cultures of the minorities, including natural resources, land rights, and so, and in particular for the indigenous people, it means that Norway have to follow this application. Another example, in 1999, the Norwegian Court Commission, who was aimed to investigate a new court structure, stated that since the Constitution Article 110A requires the state authorities a duty to create conditions enabling the Sami people to preserve and develop their language, culture, and so on, it implies requirements for the courts and their organization as well as their experience, knowledge, and attitudes of the judge. So the fact of this statement was that there was established an ordinary district court in the Sami area with a particular duty to take care of the interest of Sami law, of Sami customs, and Sami language. I was yesterday on my lecture here at the law school asked if you have tribal courts in Norway. We don't have that, but the court who was established in 2004, according to this proposal or draft, is more or less similar, the most similar you can find in Norway. And a practical consequence of this recognition is also that the requirement of Sami-speaking judges and clerks, training and so on, had to be done. And the practice today is that the head of this district court have to be a lawyer who is natively Sami speaking, because the court procedure shall be, it is not like it shall be done in Sami language, but it's one of the parties ask for it, it can be done in that way. Other consequences of this article is the establishment of the Sami parliament in 1989. We have also a special Sami Act who defend the use to, or protect the use to use the Sami language in contact with the public authorities, in the hospitals, in the courts, in the education system, and so on. And another consequence is, of course, that Norway was the first country to ratify the ILO Convention 169. And that brings me into the next topic. One of the speakers before me said that USA don't sign treaties what they are not able to follow up. And I suppose that Norway either don't do it. There is, of course, examples of some countries who exactly sign a lot of treaties not following them up. Also countries where there are living Sami people, but I will not go into that now. But when I mention it here, it's exactly that Norway probably didn't know what they did when they signed the ILO Convention as the first state. But they have been struggling hard after that to follow up the commitments, especially after several independent legal expert committees have shown that there is a rather high threshold to follow up the application, especially in relation to recognize the ownership of land for indigenous people. So let us see how Norway have tried to follow up these things. The Finnmark Land Act from 2005 is a very good example both of the Sami struggle for their land rights, but probably in the same way for the Norwegian authorities struggle to follow up the commitment in the ILO Convention. Just to show where we are in the world, now I had the map here is on Scandinavia. Norway is the colored part. And the Finnmark Land Act covers the northernmost country in Norway, Finnmark. It was also, I think it was you, Anna, who mentioned yesterday that in Germany they sometimes spend 25 years on making an act. The document on the bottom here is from 1978, and the first law proposal came in 1984, and the act was filed or adopted in 2005. And also, what is particularly not usually Norway, is that the parliament write the final preparatory works, which differ very much from the law bill from the government. Usually, the parliamentary accept the law bill from the government without any particular or important changes. Here it was a completely new law who come after the negotiation in the parliament. Also including consultation with the Sami indigenous people. So I will go a little bit into that process. Here is, how to say, the provision or the compass for the development. It's the ILO Convention 169, Article 14. And there is 3 main steps there. First is that it's that the ownership for the indigenous people shall be recognized, shall be identified and recognized. Or first, it should be recognized. The next is that it's a duty for the state to identify the land. And the third is that there should be made adequate procedures doing both the identification process and also solving land claims who will appear as a result of this process. When the Norwegian government in 2003, after this 20 years of discussion, filed their proposal or their bill for the law, they have recognized that there exist collective and individual rights acquired by the Sami and other people in the northernmost country, based on historical or immemorial usage. But they did not propose any process to identify that land. And of course, either not any procedures within the national legal system to resolve land claims. So in some way, it's okay to say that there exist rights, but we are not taking any initiative to identify them. You can, of course, go to the court yourself and try to do it, but I suppose it's not cheaper to use the court in Norway than it's here in US, so a normal person cannot risk to do that. In that case, to fight for his land right will mean that if he loses the case, he will lose his house and car and probably his wife. So therefore, there had to be another procedure if it should be adequate in the national legislation. Of course, the law bill from the government was met with a critic, especially from the Sami parliament, but also from other organizations. And there was set down an independent expert committee with the 2 law professors at the University of Oslo to investigate the case. And they stated, among others, that if the Finnmark Act should meet the requirements of the ILO Convention to recognize the land rights, the decision rules in the law must be changed so that the Sami are secured the control over all the lands according to an ownership position. Another alternative was that a particular land belonging to the Sami have to be identified. The same year, the ILO expert committee also evaluated Norwegian's status report, how Norway was fulfilling the ILO convention. And also they raised a critic, not so strong as the 2 law professors, but not to identify the Sami land rights was a violation on the Article 14. So what did the government do then? What could be the situation if the same happened in USA? Somebody probably can answer on that later. But in Norway, the government, they had used their possibilities to make an act. So the case was on the way further to the parliament. And the unusual thing happens that the parliament committees themselves started a process to develop the law in accordance with the Sami parliament. And this was based on the Article 6 in the ILO Convention, who say that it's a duty for the state to consult and negotiate with the indigenous people in cases which is on huge impact for the indigenous people. So Article 6 in the ILO Convention was the basis for the further negotiation and consultation between the Sami parliament and the Norwegian parliament. So the parliamentary committee who was in charge for this negotiation after the consultation stated that adequate procedure shall be established within the national legal system to resolve land claims by the people concerned. In other words, the majority's opinion, there was of course dissents in the committee, but the majority meant that it was clearly not a way to go just to bring this case to the ordinary court system. So they proposed to establish a special procedure how to recognize the land. And this procedure I will shortly go through before I finish my speech. Or before I go into direct the procedure, I also will give a reference to Section 3 in the Act, which clearly say that the Act shall apply within the limitation followed at the ILO Convention number 169. It means that the ILO Convention is given precedence before the law in case of contradictions. And as some of you know, Norway have a dualistic system. That means that international treaties, even if they are signed by Norway, they will not come in force as Norwegian law before they are incorporated with the internal Norwegian law. That's the procedure in Norway. The International Convention on Civil and Political Rights, it is incorporated through a Human Rights Act in 1999 with precedence before other legislation. The ILO Convention was discussed in that process, but the government say that it was only the general human rights treaties what should be incorporated. So the ILO Convention is just a ratified treaty, but not the incorporated treaty in Norway, except for the case with the Finnmark Act, where it is also incorporated through this article or this section. Section 5, on the government bill, it looks like only like paragraph 2. That was the proposal from the government. During the consultation with the Sami parliament, there was added a new paragraph 1 and a new paragraph 3. And paragraph 1 is, how to say, it's not an article who have any kind of particular legal significance, but it's a very strong recognition of the Sami land rights. And the third paragraph, who say that in order to establish the scope and the contents of the rights held by Sami and other people, a commission shall be established to investigate rights to land and waters in Finnmark. And that was what happened. And Section 29 in the same article authorizes that commission. In Section 36, there is also a decision to establish a land tribunal. So there is 2 organs established first a commission to investigate and identify the land rights, and then a tribunal who should solve or settle disputes arising from the hearings of the commission. The UN Special Rapporteur, James Onaya, he investigated the situation of the Sami people in the Scandinavia. The report was filed in 2011 in January. He stated that the Finnmark Act is an important protection of the advancements of the Sami rights to self-determination and control over natural resources at the local level, setting an important example for the other Nordic countries. And that's, of course, true, in fact, because Finland and Sweden, they have not come close to such kind of act what I go through here. But on the other hand, and that's part of my research back at the university in Tromsø, is to see how this Land Act can be implied in praxis. And there is still a lot of problems. Some of the provisions in the Act is still in direct contradiction with the recognition of the ownership to the land, because it gives the new so-called landowner, the Finnmark estate, huge competence to regulate and restrict the use of natural resources, which can belong to other people. Some more general civil procedure problems appear also, which I will not go into here. And in some way, it's good to establish a process with two bodies, but that will be a great challenge to the European Convention of Human Rights provisions about trial within reasonable time. Because what we already see is that the process will take a long time. However, this is not a result of not trying to following up the commitment of the ILO Convention 169, but rather a result of a shortcoming preparatory work, particularly since it was a politicized process who was going on to make this act. Yes. That was what I was going to say, so I'm ready to answer some questions. Anna?
You mentioned that district courts in the Sandi region or the Sami region now have jurisdiction to hear cases using Sami customary law, is that correct?
Yes.
Are the judges in those courts from the Sami group? Are they Sami themselves? Or if not, how do they go about determining what the customary law of that group is?
Yes, that's of course a good question, and it's a question what I cannot answer in full, because I think there is not an answer yet. This is a kind of law which is in development. I don't think it's like that even if you are born as a Sami, you are an expert in the Sami law or a Sami customary law. It's the same if you are born an American or a Norwegian, you are not an expert in law. So, and there is of course not a requirement that you should be a Sami to be judged there, but and if you're not speaking Sami language, of course there will be used interpreters on the proceedings. But in any case, it's written in the establishing document for this court that they have a special responsibility both to secure and what is particularly interesting, also to develop the Sami law more like a constitutional or a Supreme Court. But there is a lot of cases where people have managed to win the case in the first instance, where they base their proceeding on on Sami customary law. But when the case comes to the Court of Appeal, nearly all of them is dismissed or the other parties win. But most of such cases, we can see it is in criminal cases. And it's in particular that somebody find a kind of Sami custom who say that they should not be punished for kind of environmental crimes or such things. So one of the most famous cases, it was a Sami guy who let his dog run freely in the summertime, which is against the act of game and wildlife. And he said that it was a Sami tradition to let the dog run around, but the court didn't accept that kind of statement. But we have done some investigation on that at the university, and we can see that there is nearly no cases who managed to pass all the court system based on the Sami customary law. Yes?
I had a question regarding the Sami language. In any of the work done, was there anything that approached recognizing kind of a second language of Norway as it relates to the indigenous people, recognizing their language as an official language or a second language, or I'm not sure what term you would use. But was there any thought of that?
According to the court procedure or more in general?
Either. The court, well, probably didn't involve the court procedure, but in general, is there a thought that...
Also the fact is that the Sami language differ very much from the Norwegian language. So it's not like Norwegian and Swedish or Danish who can be said to be just different dialects. And during a long period, from the end of 19th century up to post-war period, it was prohibited to teach in Sami language. It was not even allowed for the children to speak Sami between themselves when they was in the schoolyard. Step by step, these things have changed, and from the 1970s, again, they start teaching Sami language in the school. And today, a person who is native speaking Sami, he will have teaching in Sami language in the primary school. And in 1990, there was made an amendment to the Sami Act to say that Sami and Norwegian are equal languages in Norway. So that's on the paper, but of course, it's not like that in the fact.
Which paper was that in?
It was an act, the Sami Act from 1987. It was changed in 1990 to include the provision of the Sami language.
Thank you.
Okay, we should stop there. I'm not allowed to answer more questions.
All right. Well, first of all, I would like to say that I want to express their apologies of the two other Mexican lawyers that were coming to Missoula. They're my colleagues and my really good dear friends. As we will explain during the presentation, the case of feminicide in Mexico, which is the killing of women for being women, they were helping one of the mothers of one of the victims. And her name is Norma Andrade, who had we have an interconference last Tuesday, February 14, because we were honoring 10 years of the assassination of her daughter. And Norma, and as well with the two other lawyers, were together. And for safety reasons, they couldn't make it. Norma was attacked with gunshots in December in Juarez, and then was moved to a security house in Mexico City. And unfortunately, 2 weeks ago, she was stabbed. They took her in their home, and when they were going to the airport, they thought it was kind of weird that at 4:30 in the morning, there was a truck with 4 men outside. So they preferred not to take a chance. They called the police, and that's the reason why they're not here with us this afternoon. So I just want to express, they told me to especially tell their colleagues here in Missoula that thank you for being interested in these issues and for their solidarity. My presentation will be first a general vision of the Inter-American system of protection of human rights. And I'm very passionate about the Inter-American system. I can go a lot, but that could be a whole course on that. After a little introduction, I will focus on the case Cotton Fields or Gonzalez et al. Against Mexico, who was the first case in the history that has declared or has taken the term of feminicide and including gender vision into the international legal system. And actually the first one that Mexico has lost in the Inter-American Court. I hope it works like this. I don't know. Oh, yes. Well, just to give you a broad vision about it, the Inter-American Court, it's part of OEAS. It's kind of like the UN system that Andrea already explained, but in a smaller regional version. It includes from Canada all the way to Chile, Argentina. And there is, based on the Charter of the Organizations of American States, there is 35 ratifications of the treaty. And I highlight that Mexico is part of it, as well as the United States. And I just want to highlight the Article 3 of this charter, which says international law is the standards of conduct of states in the reciprocal relations. I think it's a very strong statement that international law will be our standard to establish reciprocal, and I will almost say equal relations. Well, the human rights system under OEAS, it's mainly under two organs, which is the Inter-American Commission on Human Rights, which is based in Washington, D.C., and the Inter-American Court of Human Rights, which is based in Costa Rica, in San Jose, Costa Rica. The way the commission works, it's based in two main documents, which is the American Declaration of the Rights and Duties of Man. We're still talking in the 50s when men, we had the idea that include women, and the American Convention on Human Rights. United States is, until this point, until the Inter-American Commission, it's part of it. And especially for the American Declaration of the Rights and Duties of Man, and there is still visitations in country. Part of the process is still applied to United States. So don't think that this system, it doesn't have nothing to do with United States, because it has, and it has actually an important impact politically and strategically among the region. So the way the commission works, it's through three processes. The individual petition system that my colleagues talked about before, when a state goes against another state or files a complaint against another state, or monitoring the human rights situation. The commission has special rapporteurs as well as the UN, and they have many examples of it, like a special rapporteur for women's rights, a special rapporteur for immigrants' rights, for children's rights, etc. As well, they have thematic areas or priority areas, for example, torture, forced disappearance, which was a huge problem in Latin America, especially during the dictatorships periods. Sorry, sometimes my English doesn't come that fast to me as I would like to. But, and please feel free to tell me if you don't understand something or if I get lost in translation. So that's how the Inter-American Commission works. Well, before, when a file is, when the individuals go to the to the Inter-American Commission to file a claim, there is a whole, points of things or requirements to file a claim to the Inter-American Commission. But as I say, I won't go deeper because this could be a whole course. But let me just tell you that to the differences, I think Sally or Anna mentioned it, that the European system eliminated the commission and the individuals can go straight to the court. Well, in our continent, we still cannot do that. We still have the commission as a type of something that, I don't know what's the word, but when you put water, but like a filter, yes, thank you, like a filter before going to the court. So, but once you go pass all those requirements and the Inter-American Commission receives a claim or a case, well, the Commission has two options, either to do an inform with recommendations to the country or send it to the court. Once it's in the court, this is the Inter-American Court right now, I just know the guy right here, Don Ventura, that I have the honor to work back in 2004. And well, I know Don Diego as well, but the rest I don't know. But what I was going to go with this comment is that at the time that the feminicide case was resolved, the court wasn't like this. The court was 4 women and 3 men, and Doña Cecilia, Miss Cecilia from Chile, who was wonderful, and I just respect her dearly. She was the first woman that was elected in OEAS, because you are in the General Assembly elected. She was the first woman elected for being the court. There was before one from Costa Rica, but it was because the other judge, I think he died or something, but it wasn't elected. This Doña Cecilia was the first one, and I had the opportunity to work with her, and she was the first one who started saying about the principle of law of pro homine, like in favor of men, or if there is doubts about it, the interpretation has to go pro homine as one of the principles. She said, well, pro homine actually means pro man, so we should say pro persona, pro person. And so I just really like it. But at the time, at the case, I will talk a little bit further. The composition of the court was just the perfect time to include gender perspective into the case. The Inter-American Court, it's based on the Inter-American Commission, Inter-American Convention of Human Rights, and we have that list of countries that have ratified it, but as well to take it to the court, as well, it needs to be express, acknowledge, or express acceptance of the court's jurisdiction. And you see that those countries, and it's Mexico right there. Well, the court has 3 different competences or functions. The first one is adjudicatory, of course, that or contagious, cases, the advisory, and the provisional measures. I will explain those. The adjudicatory one, well, only the states can, go in a case against another state, or the commission can bring a case to the court. This, in this case, it's in the name of the individuals that already filed the claim before the court, before the commission. So still, we see that the individuals are not the main ones before the court, but it's okay. And the court determines if there is international responsibility or not of the state regarding the human rights included in the convention. And very interesting, since 2007, the court started a new practice, which I found very interesting. They started having hearings to monitoring the compliance of the judgments. That's a huge advancement because before this, the court will have sentence, but there was not a follow-up, and there was no that other than the political pressure on the states. This is like an extra pressure on them, and I think it's a really good practice. The other function of the court is the advisory. And this is kind of like the alternative when the state don't want to really sue another state because strategically or because of political reasons or whatever. So they can, a state can just kind of go to the court and ask an opinion. And the ones that can ask an opinion are members of OAS or their bodies. And for example, I remember the advisory opinion number 18 that was about immigrant rights, and especially on the topic of labor rights, because many countries, if that sounds familiar, decided that if an immigrant comes to a country undocumentedly, they couldn't ask for labor rights because they didn't have a permission to come in first place to work. So those people couldn't form unions or ask for labor rights. And so Mexico put as the advisory opinion to the United States. I think Mexico was actually in the back of their minds thinking in suing Mexico. And that sounds like case Avena in the international court. About immigrant rights. And that was actually, I remember very well, because that was my first time at the court, and I was 23 years old, and I was just shaking and just, oh my God. But it went well, and after Mexico actually used these legal arguments before the court, and it was the first case that Mexico won against the United States in the international court because of the death penalty of the 53 and ended up with 51 Mexicans here in the United States that didn't have, translators or consular representation, et cetera, et cetera. That could be another topic, but anyway, the other function of the Inter-American Court are the provisional measures. And the provisional measures are extremely important. That's when the court asks the government to protect these people that are involved in cases before the court, or even if they haven't yet brought to the court, and to avoid irreparable damage. And this is very important because actually the woman that we talked last Tuesday in the UC Theater and that was supposed to come, they already asked for provisional measures before the Inter-American Court, and they have been warranted. So the state of Mexico now is responsible for protecting them, and if they die, it will be Mexico's responsibility. So I think these provisional measures are extremely important, especially in countries like mine, where being a human rights lawyer, a human rights defender or activist, it's almost like, like not like a death sentence, but very close to fear for your protection. Well, this is Norma Andrade. I just wanted you to know her because I just talked about the provisional measures that she had, and because she talked to us. And right now, I will focus on the case Gonzalez et al., the Cotton Fields versus Mexico. And that's a picture I took in the place where bodies were found, and that's the cotton field where that took the name for the case. Just to give you an introduction of what was going on, and it's going right now still in Mexico, is, as you can see, right under Texas, right next to El Paso, there's a place called Juarez, right where Pancho Villa started the Mexican Revolution. And right there in 1993, and to the present time, people started noticing that bodies of women just started to appear in the desert, in lands, in the middle of the city, in urban areas, and the mothers were organizing themselves to ask for justice. But just so you know that the term was started crafting into what is called feminicide. Feminicide wasn't first used in Mexico, but it was first used by, femicide, that's what Diane Russell say about a continuum of sexual terrorism of women and girls. But then in Mexico, Marcela Lagarde said that feminicide was a repeated violation of women's human rights that culminates in assassination, thinking and linking the concept of genocide, but applying it to women as a target. And the court, that's a quote from the court, from the decision, from the rule, in the paragraph 143 says that gender-based murders of women, like feminicide, it's known as a gender-based murders of women. So basically, we're talking feminicide is the killing of women for being women. And what happened when all these when the organizations started asking for justice? The government response was the state public prosecutors say, I quoted there, women who have a nightlife, go out late at night, and come in contact with drinkers are at risk. It's hard to go out on the street when it's raining and don't get wet. So basically blaming the victims themselves. Blaming they were saying, they are prostitutes, they are going out at night, and this is a dangerous city, but actually most of these women that in the first decade they started being murdered were maquiladora workers because of the NAFTA agreement that positioned all these assembled factories along the border that paid $5 per 8 hours of work. And it's not enough if you have a family, so you have to work extra time, and then you have to come back to your home at 2 in the morning, at 3 in the morning, at 4 in the morning, instead of at 6 and just sit and watch television, or at least rest. So, but the government couldn't see that reality of where women were surviving. So the lack of an effective and official response generated this context of impunity and kind of set a precedent for the rest of the not just of the city, but of just the rest of the country, because it was a message that, women were nothing. Women are replaceable. And just to tell you, these are the names of the case. Esmeralda Herrera Monreal. Esmeralda, with 14 years old, under international law, the Convention of the Rights of Children say that if you are under 18 years old, you're considered a child. So she was working, cleaning a house, but when she went out of work, never was seen again until her body was found in the cotton field. Laura Berenice Ramos Monarres, she was a student. Claudia Ibet Gonzalez, she's one that really struck me because she disappeared on my birthday about October, and when I turned 21, and she was 20, so she didn't make it to 21, and she has the last name of my mom, so it was very close to my, surroundings. So, and the mothers, Irma, Benita, and Josefina, are the ones that actually went into the internet, and I don't know if somebody told them, and they filled the complaint before the commission. There was no lawyers around when they just did it. So the help of the ANAT and my friends came a little after they filed the complaint, but I thought it was just so, they were just tired of having the answer from the government that I will quote later. What was the answers from the police? And so let's go to the proceeding before the court. Uh, well, these are the answers from and these are quotes from the sentence. For example, in the case of Esmeralda Herrera, that as I said, Esmeralda was 14 years old. The police, when she was reporting the disappearance to the police, they told her, had not disappeared, but yet out with her boyfriend and wandering around with her friends. That's what they told her that she was doing. Say, well, if anything happened to her, it was because she was looking for it. Because a good girl, a good woman, stays at home. And actually, it's very linked to the state response, because when the mothers started getting organized, what the states did, it was publish a bootleg, and they give it around the maquiladoras, the sample factories and all that, and the bootleg say, don't go alone, be always with somebody, and try to don't go out at night. So basically, it was like a war zone for women. And for example, for Claudia Ibet, the answer was the official told a friend of her of her daughter that she's surely with her boyfriend, because girls were very flighty and threw themselves at men. And to the mother of Laura Berenice Ramos, they told her all the girls who get lost, all of them, got off of their boyfriends, with their boyfriends, or want to live alone. That's what she received. And then what the police told her, to the mother of Laura Berenice, who was a student of 17 years old, they told her to her mom, go home and relax, have some heladas. Heladas means cold beer. And offer a toast to our health, because we can go with you. Right now, when she was asking, please go with me and help me look for my daughter. So this is the kind of response these crimes were having had in Mexico. The message that this impunity sent, it was not just the narco-traffickers, and let me mention that we organized this event because Lilia Alejandra, the Norma Andrade that you saw the picture, her daughter disappeared on February 14 because the narco-traffickers gave women as a Valentine gift. And not just Lilia Alejandra had disappeared in February 14, but many women along the whole year. And it started as a very gross violence. The bodies were found with extreme signs of brutal sexual violence. But then what happened is this, the green part you will see is just bodies that were found, or sons that bodies were found in land. Black, you cannot see it very well, but it's in an auto or car, and then, pink, it's in a hotel, orange in a bar, but the red ones are homes. So what we see now, after all this impunity, it was that the message was that women were not important, and if you do something, it won't have any consequence. So in the shelters for domestic violence, more and more women started reporting, well, my husband told me, look around you. I can kill you and nothing will happen. And that's when we started finding that 60% of the bodies were starting finding in their own homes, where supposedly, where you have to feel safe with the people that loves you the most. So we were talking about a big incidence of domestic violence and without punishment. So the case is important because it takes on, it declares a state responsibility on the acts of private actors. What the government said before the court, say, well, there is not proof that it was my officials, my soldiers, of my police that killed these women. Of course, there was no evidence because there was no investigation or no serious investigation. So nobody knows who killed them, so there was no proof. But the problem was that as Anna and Sally and Andrea have mentioned that human rights obligations are not just by omission, are by action or affirmative obligations, which means that, for example, we have the right to life. And the right to life means that the state shouldn't kill you. So by doing nothing, it's already compliant. But that right to life has an affirmative obligation, which means that the state had to take measures so nobody killed you. And if somebody killed you, has the obligations to investigate who killed you and find it and give an effective and sanction. So, and especially in this context of mass violence against women and structural discrimination that was coming from the institutions, from the agents, from the government. There was a problem. There was a big problem in the case. And maybe this is the biggest victory among other ones, but this is one of the biggest victory of the case. And it's that the court had jurisdiction over the Inter-American Convention of Human Rights. And there is another convention called Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women. It's kind of like CEDAW, but for our continent. It's the same thing, but to our continent, it's known as the Convention of Belém do Pará, because it was signed in Brazil in the city of Belém do Pará, so everybody calls it Belém do Pará Convention. Well, this convention in the chapter 4 say that for violations to this convention, you can file a claim to the Inter-American Commission, or you can ask for an advisory opinion to the court. So the Mexican states say, well, you shouldn't judge me if I violate this convention, because you don't have the competence or the jurisdiction to look into that convention. You can declare me or look into my responsibility based on the Inter-American Convention of Human Rights, but not in Belém do Pará. So the court say, well, I have under the Vienna Convention of the Treaties, have instruments and principles to interpret the law, international law. So they realized that the chapter 4 was saying that it was giving competence to the court to know about the violations of the CEDAW because of the purpose of the treaty and because of the explicit suggestions of filing a claim before the commission, and because it was just, well, as I say, we can talk about theory and all that a lot for a long time, but just because of the time, let's say that the court decided that in reaffirming that it had a jurisdiction over this convention, and this meant, and this is the victory of this, as a lawyer I see it, this meant that the women's rights, it was reaffirmed as a human rights, because sometimes it kind of seems like are two different things, and human rights are here, and women's rights are here, and they're not connected. So women's rights are human rights, they're universal, they're inalienable, so I cannot quit them, nobody can take them out of me, and the most important thing, they are justiciable. So they are defendable before court. So there was not anymore Belém do Pará, that document that is looking beautiful, but there was no court to take them and enforce them. So, and this is the first case. This is a landmark case. There was other intents before with the case in Peru, Loaiza. It was an anthropological woman that was murdered, and they tried it, but until this case was when the court reaffirmed and say the Belém do Pará is justiciable. So the resolution of the case was set in three big things, which actually are, we were talking about the affirmative obligations of the state, which is prevent, investigate, and sanction. So when the government say, well, there is no proof that my police or my militaries did it, the court say, well, that's true, but you didn't prevent that this keep happening, didn't investigate, and didn't sanction. And as well, Mexico say, well, then you have to declare me responsible because there is more men that are being killed in Mexico. And they came with big numbers and statistical things, and they say, well, yes, that's true. It's true. There is more men that are killed in Mexico. But the problem is how men are being killed in Mexico, how women are being killed in Mexico. Men are being killed in the hands of another man. They are being killed in the street, and they're being killed with what we call white weapons, or armas blancas, with our knives and all that, and weapons, guns. And women are being killed in the hands of another man, not a women. Women are not killing women, are being killed by men, and they are being killed mostly inside their homes and those in the street, but with extreme signs of violence. I'm talking gross sexual violence, mutilations. When a few years ago they captured one of big narco trafficant, and when they captured him, he had a necklace, and the necklace was a real nipple of a woman. And that's the kind of violence that we're talking about that bring a feminicide to the international arena. So the court decision decided that Mexico violated the obligation to not discriminate, and in connection to the right of life, the right to physical and mental and moral integrity, the right to freedom from torture or cruel, inhuman, and degrading punishment, personal liberty and security, and the right to a fair trial, and simple and proper and effective recourse. And just to refer to the last two that may be not that clear, is in Mexico, we had the public prosecutor. We call it Ministerio Público. And when you go and present a claim, the ministerio, or the public prosecutor, just so I use the same terms here, decides if, see the situation, and according to law, should decide if there is a crime to prosecute or not. I think it works kind of like the same here, right? He represents the society. So in Mexico, women will go and ask the public prosecutor to prosecute, and the public prosecutor won't prosecute because in his eyes there was nothing to prosecute. With this sentence, Mexico was declared having responsibility for that because there was not fair trial and there was not access to justice and all that. So just to explain those 2 points, why the court on those two, because the other ones are kind of clear why, but not the last two, right? So it was because of the denial of access to justice. So the bigger picture will say that the court decided that in Mexico there was gender-based violence, and that gender-based violence constitutes discrimination. And I say it that simple because I think if we fight discrimination against women, we can avoid further things, something as worse as the killing of women for being women. That's why we have to pay attention to the simple and little details that looks like, oh, it's just a little discrimination. And so I think just to, and that picture, it's right in the border between Mexico and Juarez and El Paso. It's right where you have to, right after that cross, you have to take your green card or your visa and show it. So I thought it was very symbolic. Anyway, the sentence has some reparations. And the reparations are like in three levels. Are symbolic reparations, and there are measures of non-repetition and reparation measures. Well, I kind of got a run right in there, but anyway, Well, the symbolic reparations were that the Mexican state was obligated to go before the national media and in national televisions and publish in national newspapers the recognition of this responsibility, that Mexico asked for an apology to the mothers and the families and asked and recognized its responsibility. The reparation measures were more into the individual level, which was meant that the families receive it just in this to the three women that was the case, not to all of them, but they received a monetary reparation because it's losing a daughter or losing a family member is irreplaceable. So since it's irreplaceable, the only form to reparate, it was monetary. But the important thing that I would like to focus now is the measures of non-repetition, which were the structural changes of the country. First, okay, I will go quickly. Well, first, the recognition of feminicide. All of a sudden, the term feminicide that was in the anthropological and social arena became law. And right now, Spain is declaring feminicide as a crime. Argentina, Chile, Honduras, Guatemala, Peru. Well, I think the impact, it wasn't not just in Juarez, not just in Mexico, because now Mexico has included feminicide as a crime, but the impact was in the region and in the world, and I think it will spread. As well, there was law reform, structural changes, and the proposal of a DNA bank that still haven't been done, but it's coming. Of course, there is challenges, and the challenges, it's just to come ensuring that the government will thoroughly comply with the sentence. And this is Benita, one of the mothers of the victims. And this is what the monument looks like. And I say challenges, and specifically here, because the government just wanted to include 3 of the victims that were of the case. They didn't want to include the rest of the names of all the victims. And so the mothers rejected, and they didn't show up when the government opened this monument, because it wasn't how it was according to the petition of the victims. And this was the other victims that were found in the cotton field. And specifically, I would like to talk about Merlin Elizabeth. Okay. About Merlin Elizabeth Rodriguez Saen. Her mom was when this monument, the government came out with this monument, and she said, "Well, I've been so afraid of ask for justice. I never go out and ask for nothing. I don't protest, and I'm not, because I'm just afraid I will get killed like the other activists." And this was the first time she will go with the picture of her daughter. So I think, even though the government haven't complied according to the sentence, I think it has already a reparatory impact into other victims. And just to finish, I would like to say that this event was dedicated to Lily Alejandra, who disappeared in February 14. But as well, I would like to say to Norma Andrade, her mom, that have been fighting for a decade now. And I would like to thank, I didn't say thank you to start, but I would like to say to finish to Laura, Andrea also, and Rita, and everybody in the law school and the international programs and in the community of Missoula for just really caring about these women that nobody cares about. And for having this space to generate discussion. I think, their problem is our problem, and your problem is our problem. And thank you.
you all. I'm Rebecca Rosenhan. I'm a filmmaker and lecturer on law. I'm going to talk a little bit about the experience of making this film, War Done Done, and show a quick clip from it. It's about a trial at the Special Court for Sierra Leone. So a little bit about my background briefly. I was trained as a filmmaker, and then I went to law school.
Well, the term when announced it.
And then navigate. Is there? Let's see it. Okay, we'll just get back up there. Yeah. So I was trained as a filmmaker, and then I went to law school and worked in public defense. I was an investigator at a public defender's office, and then I went to the Special Court for Sierra Leone, which is a UN-created war crimes tribunal, and worked on a defense team there. And I had a very hard time returning back to the States after this experience and trying to explain to friends and families why I thought it was really important work to defend someone who was accused and very likely guilty of war crimes and crimes against humanity. And so I set out to make this film in part in response to that, to explain why international criminal defense is very important. And we set out originally to make a film about a defense team, not on the trial that I worked on, but of a leader of a different warring faction. And in the end, it actually turned out to be more interesting to tell the story from lots of different perspectives, not just the defense team. And so I was going to show a really quick clip, but maybe I'll just keep talking. So a little bit about the background of the Special Court for Sierra Leone. So international criminal justice was born after World War II in Nuremberg, where the Allied forces came together. And at the beginning, Churchill says, how many people should we just line them up and execute them? And Stalin says, let's go ahead, let's execute 5,000 Nazis. Let's just line them up and shoot them. And the Allies come together and they agree that this is not the best course of action, and instead it's really important to bring the rule of law to bear on these really egregious crimes. That in the aftermath of a war as terrible, atrocities as terrible as the Holocaust, that to impose the rule of law on this moral vacuum is a really important thing to transition into peace. And then international criminal justice is completely dormant after Nuremberg, and it's not during the Cold War. Really, nothing happens until the International Criminal Tribunal for the former Yugoslavia is born in the 90s, and then the international community is forced also to respond to these atrocities in Rwanda, and so the International Criminal Tribunal for Rwanda, ICTR, is born. And both of these tribunals are very important, but also very problematic. They're created from Chapter 7 powers of the United Nations, and in some ways I think feel like they are imposed on the countries that they are claiming to bring justice for. And those countries either were not capable, could be argued were not capable of having their own trials, or didn't have the political will to do it, or there's lots of reasons why justice should come from the outside, but it made the process of bringing justice very complex. And neither of those tribunals took the responsibility of doing outreach and engagement very seriously either. So in the first, it was many, many years into the operations of the International Criminal Tribunal for the former Yugoslavia that they actually had outreach exercises. And so that's the clip of the film. I'm just going to show, I think this is right. We're going to meet it's a 5-minute clip. We're going to meet the chief prosecutor, then the defense lawyer in this case, and then see a little bit of a outreach event. And the only thing you need to know, this is like 7 minutes into the film. For the first scene of the film, You meet the accused war criminal, Issa Cisse. You find out, it actually starts with his conviction, where he's convicted of war crimes or crimes against humanity, and then it backtracks 5 years to the beginning of the trial, and it gives a little bit of a very, very brief outline of what the war was about. Rebels called the RUF launch a war in Sierra Leone to overthrow what they consider to be a corrupt and tyrannical regime, but attack civilians in the process. And more than 70,000 people die. There are countless rapes, mutilation, torture, very terrible things. And so, I can't remember at this point in the film, the difference between this court and its predecessors is that the government of Sierra Leone actually, the president of Sierra Leone wrote a letter to the United Nations requesting a tribunal. So this is not the United Nations deciding this is an important thing and imposing it, but rather this is the first time where an international criminal tribunal exists in the country where the war crimes took place since Nuremberg in Germany, and it comes at the request of the government of Sierra Leone. So I think that's all you need to know.
Get the lights, please.
I had the privilege and frankly the honor of being the chief prosecutor of the Special Court for Sierra Leone from 2002 until 2005, and throughout that time period I got a chance to truly meet, appreciate, respect the horror that people of Sierra Leone went through. The question is the justice we seek, the international community, the justice they want? And so we can't just go into a particular area and just assume that we have all the answers. We have to sit back at first. And that's why I literally walked that countryside for 3 years just to listen. Talking to people who just several months before were killing each other. They began to realize that this wasn't going to be a kangaroo court, that this was going to be something for the people of Sierra Leone.
Seek justice for them. All we can tell you, it is you that have to decide the destiny of this country.
I got to know, respect, and frankly love my victims, not so much in the sense of overstepping my legal obligations, but just knowing what they went through. I mean, as I am describing to you now, I can still smell and taste death. That's important, not because of anything other than the fact that, frankly, it builds up a righteous fury in you to seek justice.
I think you can only get to know someone in a limited way, in a lawyer-client relationship, and especially one where the client is incarcerated and fighting literally for his life. Yeah, I mean, I'm very happy to have met him, actually. He's an intelligent, charming, at times bad-tempered, at times very angry. I mean, everything in a human being, but overall, a man who I've come to like a lot, actually. And but for these circumstances, then I could see no reason why we wouldn't have been friends. I'm sure he's capable of many things. And I'm sure anyone who fights in a war for 10 years is capable of many things, but How somebody is reflected on a prosecution allegation rarely sums up the individual. The way it happened here is Mr. Crane and his colleagues chose the people they thought bore the greatest responsibility, and they sent out their investigators to find evidence in support of it. You can't select this few people and expect the historical narrative to be particularly balanced or accurate.
Here we are today, about to commence yet another trial, this time of the case involving the RUF group of indictees. The mission of this court and the resolve of the international community is to bring an end to impunity and to contribute to the peace and reconciliation process within Sierra Leone. I would like to invite the prosecutor of the special court to make an opening statement.
This is a tale of horror, beyond the Gothic into the realm of Dante's Inferno. These dogs of war, these hounds from hell, unleashed by cynical, internal, and external criminal actors.
You will limit, the objection is sustained. You will limit your observations to the facts. To the facts. Please, to the facts.
When I was giving my opening statement, I can remember looking directly at Issa Sese. I didn't see anything. It's the first time in my life that I actually looked into the eyes of a human being and realized they have no soul. The hairs in the back of my neck actually bristled. From my point of view, it was almost a religious experience.
These war crimes indictees who now stand before this tribunal, before this country, before mankind to face justice, were part of this union, this joint criminal enterprise. Issa Sese, battlefield commander and leader of the RUF, Maurice Calonne, and Augustine Bao. These were the leaders, the commanders of an army of evil, a corps of destroyers, and a brigade of executioners bent on the criminal takeover of Sierra Leone, once the Athens of West Africa. Today, due to these indictees, a sodden backwater marred and broken, lapping against the shores of civilization.
Most of we not going for left, we open and I have to go free time at this court. Now that make the court a bring one section where they call outreach section. That is, the people they can meet on our community. All are not going to go on a free time for go sit down at this court. We don't bring the courts now and do not follow on a seat. We neutral. We not there for prosecution, we not there for defense. We there not for tell on her what in the courts they do and what in the courts not they do. Anything where you know understand, anything where doubt you. If you get question, please raise your hand and ask. Noise. On a picking them.
After all the theory say,
yes, sir.
The witness are willing to come on. But after all exercise,
yes, sir.
You know they are nothing. For say, that people are not so good for do that. And then we don't talk say, before you come on and you go testify, small thing and they will for do for now. But now they don't forget, that people are welcome for go testify and don't forget about them.
When I get a question when we daddy ask, the special court in your work now for bring peace through justice. Now that's make way international donor they come, United Nations they pour money per organization there, for let them build people they host there, for let them build schools there, for let them build structures there, water well there, for we will they suffer. Not to the special courts in your work for can build toilets, for can build hosts, for can build school. But the special court they ensure say we get peace in this land through justice, so that this kind of will happen, and not go happen again.
This court
So I think that's sort of enough to set up the basic, some of the basic questions I wanted to pose here and with this film. But I think that maybe I've shown enough to begin to ask the questions about what is the measure of success of international criminal justice. And I think that's actually a really hard question to answer. And in part because international criminal tribunals are so fragile politically. They depend on the political will of donor countries, of important members of the United Nations. The special court indicted 13 people. David Crane, the first chief prosecutor who you've met in these clips, indicted and prosecuted Charles Taylor, the president of Liberia, who launched the war and trained the rebels and funded them. David Crane also wanted to indict Gaddafi in Libya, who also trained and armed the rebels. And the donor states that supported the Special Court for Sierra Leone told him, we will pull your funding if you do that. So, I mean, in my mind, all justice is somewhat political. This sort of justice is very political and transparently so. And I think there's a debate at the end of the film. So the film follows the trial of Issa Cisse, who is accused of these terrible things, but works to disarm the rebels. And the question is, if you really throw the book at this guy, if you don't give him if you don't reduce his sentence at all for the good things he did to end the war, what's the message that you send to the rest of the world? And the defense says the message that you send to the rest of the world is don't disarm. If you're invariably going to serve the rest of your life in prison for the crimes that you committed, then there's no incentive to work with the international community and disarm. So it continues war and it will prolong violence. And the prosecution responds and says, no, that's not true at all. The message that it sends is don't commit these crimes in the first place. And I think this is, just a fascinating debate that does not have an easy resolution, in part because international criminal justice is so young. But I think it's very troubling that it appears that we only prosecute the leaders of weak states or failed states when we don't hold our own leaders accountable for very serious crimes, or the leaders of other powerful states. So I think that debate is yet to be resolved, but I think it does raise some troubling questions. And so one of the other questions that's also difficult to resolve is what is the measure of success of the special court? And that is a question we posed to everyone that we interviewed. And both Wayne Jordache, the defense lawyer who you met, and Stephen Rapp, who's the second prosecutor who I met in these clips, answered that exactly the same way, which is the Special Court for Sierra Leone will be a success if the trials are fair and if the trials are perceived as fair. And that's, I think, a lot of the work that the court did with outreach, with bringing these televisions and power generators into rural communities to show excerpts of the trial, to create a space for discussion, to strengthen relationships with civil society leaders and bring them into communities and have thoughtful debate and things like this. So it's both the exercise of justice and the perception of justice that I think the court was working really hard to do. There were other people we interviewed. One of the judges, whose interview we actually didn't include in the film, but he said the Special Court for Sierra Leone will be a success if Sierra Leone remains a country at peace, which to me seemed like hugely problematic because there are lots and lots of variables beyond what this court is capable of doing. Is there war in does war spill out in Guinea and cross the border? Are there does the new government uphold its promises? I mean, there's lots of things that the court can't do. But what I think we tried to do in the film was to lay out the sort of promises and expectations attached to international criminal justice and separate those that were realistic and reasonable were those that seemed more political in nature and necessary to the fundraising efforts of the court. So I hope that's a good enough setup to get you to. We're screening the film tomorrow at 3 o'clock.
3 to 5 p.m.
From 3 to 5, and you can see the whole film then. And we'll have more time to talk about it. I'm happy to answer questions, but I did very quickly want to thank Andrea for having me and for this is great. People together talking about human rights. It's important. And yes, and to also connect. I'm actually here, I'm just finishing a second film that we shot entirely in Montana on the 2011 legislative session on the issue of medical marijuana. We're screening excerpts of that film at the Big Sky Film Festival on Monday at 5:45. And there's lots of other really wonderful films that are being screened at that film festival. So for those of you guys interested in social issue documentary or not social issue documentary or just great movies, you should check out Big Sky. It's great. Any questions?
Well, when would this one be generally available where you could?
We're done? Or the new one?
This one.
It's available now. You can buy DVDs online, or I'll bring some to the screening.
What's it called?
We're Done. It was broadcast on HBO 2 years ago.